I want to thank Chief Justice Rabner, the Honorable Glenn Grant, as well as all the other people who worked so hard to put this conference together. As noted, I'm the president of the Trial Attorneys of New Jersey. And before I commence my remarks, if you experience either a slight or severe case of deja vu, it will be because some of the remarks that I'm about to make echo very closely those made by Mr. Carmagnola so eloquently before. But what strikes me as important here is, despite the various facets through which we approach this issue, there is a fair degree of unanimity about the need for real change, real data-driven analysis, and the Trial Attorneys of New Jersey wholeheartedly supports that effort. And again, we are looking forward to be continued partners in the effort to make real change to ensure that the jury selection process is indeed fair and that any impermissible bias is stamped out. For those of you who don't know what the Trial Attorneys of New Jersey is, it's basically what I refer to as a non-denominational group. We have criminal lawyers, civil lawyers, plaintiffs, defense. The common thread that binds us is the mission to support the interests of the public, the bench, and bar in connection with the trial practice. I can't think of a better way to serve Tange's mission than to be part of this process and to hopefully not just reiterate, but to add some informed perspective to this initiative that is at its nascent stages perhaps, but nevertheless critically important. I took Wednesday, I had to be remote, but having watched the entirety of the process, having read the submissions that were submitted in advance of this conference, I have to say it's inspiring. The fact that people in a system are willing to analyze it, to be clear-eyed about the limitations of that system, and are willing to change it potentially in a wholesale way, I would argue is the best of what our profession has to offer. And as I said, hopefully the end goal here is to make sure that despite divergent views, we find that common path to stamp out any impermissible bias. And certainly Tange is fully supportive of a thoughtful and collaborative approach, which was a phrase that the chief used on Wednesday to that process. As I offer my remarks today, I'm mindful of the sobering reality that inequities continue to exist in our society. Those inequities breed lack of faith in our pillars of how we all engage with society. The judicial system is one of the foundational predicates for that society, and jury selection through the lens of the Trial Attorneys of New Jersey is such a critical part of that. I'm also mindful of Dr. Eddie Glaude's stark reminder of what is at stake for all of us as we embark upon this journey. It could not be more important as to what we've all devoted our professional lives to make sure that we get this right and that we do it in a measured and careful way. As my grandfather, who was a carpenter, used to say, measure twice, cut once. We have some time, let's get it right. I also am mindful of the adage that I'm going to steal from my philosophy professor at Rutgers down the road from 30 years ago, to think like people of action and act like people of thought as we approach this critically important issue. I hope my philosophy professor knows that I actually learned something 30 years ago in that class. Now, to the ends that I've thus far espoused, Tange, its board members, and its officers have met repeatedly to discuss some of the issues relevant to this conference. The ultimate result of those deliberations was an endorsement of the State Bar Association Working Group's interim report as it relates to the concerns addressed therein and some of the thoughtful recommendations to try to offer as data points and suggestions as we tackle this issue in a holistic way. I'll attempt to briefly amplify some of the analytics that underpin Tange's endorsement of that interim report. First and foremost, as I noted, Tange is fully supportive of a holistic, exhaustive, and data-driven approach to analyzing where the weak spots are and to hopefully fix those, specifically as it relates to the noble effort to stamp out any impermissible bias in our jury selection process and generally our system of justice. Dr. Mary Rose did an admirable job of distilling the data available to her possibly limited though it may have been. And what struck the TANG members in our deliberations was it was abundantly clear that more data, more analysis, and more thought needs to be brought to bear to tackle these weighty issues as we, to borrow the working analogy, seek to redesign or rebuild our house. The necessary data collection may be at its nascent stages, but the mandate from state versus DANGSIL is a critically important tool in that process. And as Mr. Kokora said before, it may not be a surprise that trial lawyers are very protective of peremptory challenges. And it's no surprise that that will be part of what I discussed today, at least the concerns that TANG members have about any alteration of that peremptory challenge process without a concomitant adjustment of the role of attorneys in our voir dire system currently in New Jersey. Now, while more data and analysis was a main theme from Dr. Rose, there are a few things that are, I think, beyond dispute from TANG's perspective. One, as I mentioned, is it is abundantly clear that the manner in which potential jurors are summoned to the courthouse to serve in veneers and potentially serve on juries must be studied further and then modified to ensure that the people who come to serve actually represent our communities. It is undeniable that there are, and it's alarming, frankly, some of the statistical data analysis offered by Dr. Rose. And in that respect, TANG is fully supportive of a holistic effort to make those changes once there is sufficient data set and input from interested stakeholders. Second, it seems unclear, at least at present, that the use of peremptory challenges by attorneys in New Jersey is substantially contributing to or driving impermissibly biased diminution of representation of cognizable groups on juries. That's not to say that more data may not affect that calculus, but based on what is available today, it is TANG's considerable opinion that more information would need to be garnered before there could be a cause and effect relationship between peremptory challenges and systemic underrepresentation of cognizable groups. Now, one of the key things that Mr. Kokora had noted is the interrelationship, at least from TANG's perspective, of peremptory challenges and the role of attorneys in the voir dire process. I alluded to this earlier. Many of TANG's members have served in the trenches for years, if not decades, trying cases in New Jersey. Many of us also have tried cases in other jurisdictions, some neighboring states and commonwealths, and some across the country. One notable area of distinction for New Jersey voir dire is the relatively truncated role that attorneys play in that voir dire process here in New Jersey versus in other jurisdictions. I know modifications have been made over time to try to affect that and to appropriately target for-cause challenges. Respectfully, more can and should be done to expand the role of attorney involvement in the voir dire process. It is important to note that peremptory challenges preserve what has always been characterized, at least in decisional law, as a substantive right. It has been memorialized in our court rules, codified in statute, and the case law is, as set forth in the working group report from the State Bar, weighty in terms of the importance of peremptory challenges, particularly in the criminal context when individuals are faced with threats to their liberty. It's also important in the civil context. Anyone who's ever been a litigant knows my case is really important to me. Now, when comparing New Jersey to other jurisdictions, it is abundantly clear that voir dire here is much less attorney-driven than in other areas. And any thought of reducing or eliminating peremptory challenges without a corresponding assessment of the increased role of attorneys in the voir dire process, I think would be premature and respectfully not data-driven, at least not at the moment. Now, just to sum up, because I know my time is running short, I want to reiterate that we are willing and able to help and be a partner in this effort to make real change. We're honored to be a part of that process. And what we would strongly encourage is the continued accumulation of data so that we can make as my grandfather would say, one cut after two measurements. We have to proceed with care. And we certainly endorse more robust involvement by attorneys in the voir dire process. And I commend to you the interim report from the State Bar if you haven't had a chance to review it with any care. But there are a lot of recommendations, some of which were echoed by Mr. Roper today in his thoughtful presentation about how best we can tackle this issue in a holistic way, rather than targeting certain things without the requisite data to support those initiatives. Particularly as it relates to Batson and Gilmore-based challenges. There are a lot of interesting thoughts that have been brought out over the course of this conference. Now, I very much appreciate the opportunity to have taken part on Tanja's behalf, and I look forward to hearing from the other speakers today. Thank you very much.